traveling these days?
Oh, well, good, good.
Let's
All
go ahead and get
right.
started.
Well, yeah, sure. All right. Well, good afternoon, everyone. I'm Jonathan Bricker, and I'm the chairman of the Arkansas District Export Council. And I want to welcome you all to the webinar for legal aspects of an international sales contract. I'm very excited about this class because now everyone will get a chance to meet Graham Catlett. He's kind of like the godfather of the deck. So anytime I get a chance to talk with Graham is a good day. So thank
Yeah,
you for
we
being
mean
here.
that in a good way.
Absolutely, absolutely. I'll start today by thanking our sponsors, the Arkansas Economic Development Commission and Arkansas Manufacturing Solutions. With their help, we are able to provide these webinars free to all of the attendees. So thank you to both of those organizations. They are great strategic partners for the deck. I really appreciate you all joining us today. For those of you on this call that aren't quite sure who the deck is or what we do, allow me to do a quick introduction. We're a private, nonprofit organization that brings together experienced international business people with potential exporters. Each deck member has been appointed by the U.S. Secretary of Commerce for their real-world expertise in international trade. We have a ton of experience within our council in many different sectors. Now, having said that, we don't know all the answers to all the questions, but we can introduce you to someone that does. We are a community of connections within the exporting world. My hope for the day is that you walk away from this webinar with more confidence in your exporting abilities. And if you have any questions throughout the webinar and you don't feel real comfortable asking it here, I invite you to reach out to us on our website, exportarkansas.org, and we'll have one of our members reach out to you. Basically, we want to be your strategic partner to help you grow your exports, which helps grow your bottom line. And while I've kind of got a decent sized audience here, I also want to bring to your attention and invite you to join us. We're announcing our 14th annual Governor's Award for Excellence in Global Trade, and we'll be having that on Thursday, October 3rd. So it's an awards lunch. It has a networking reception with the Arkansas business community, and we'll be at Robinson in downtown Little Rock. What these awards do is they recognize the exporting success among Arkansas's manufacturers and agricultural companies that are actively trading in international markets. We present each winning company with the trophy and a certificate during the ceremony. And then the companies are also profiled throughout the year as winners of the Governor's Award for Excellence in Global Trade on our website and throughout the social medias. So we've now started looking for sponsorships, and we will open up the applications here, probably within the next month or two. So please check that out. Before we begin, I'd like to ask everyone to make sure that you keep yourselves muted and either raise your hand or put your question in the chat if you'd like to ask a question. That way we don't have a bunch of background noise interrupting Graham as he speaks. So I appreciate everyone's help with that. I'd like to introduce everyone to your moderator this afternoon, Mr. Rudy Ortiz. Rudy has recently retired from the Arkansas Economic Development Commission and is the previous chairman of the DEC. Today, he owns Strategic Business Services, LLC, where he helps companies in a wide variety of international and exporting needs. He's a partner with Cross Border Business Consultants, which is a global team of international consultants working together to help companies to initiate activities in other countries. For these reasons, he is the DEC's education chair. Rudy, thank you so much for spearheading this. And with that, I'll turn it over to you.
Thank you, Jonathan. I really appreciate it. And as it turns out, the organization Cross Border Business Consultants has now kind of been transformed into the Global Market Entry Consultants. But many of the people who were in the previous organization are now with what we call GMAC, the Global Market Entry Consultants. But thank you so much. Still doing exactly the same thing, largely with the same identical people. And So, we're going to have a great class today because Graham is not only an expert in his law advice and information, he has a lot of personal expertise in exporting and doing business as a businessman, not just as an attorney or as an international attorney, but as a businessman doing international business. He was one of the very first, if not the first, person who brought American food to Russia, of all places. And I think he was there for like 12 years or something like that, and had was doing business with restaurants, hotels.
Were you joining that international contract thing, or did you have any
I'm sorry,
interest in it?
my apologies. I think somebody's got their
Okay.
mic on. Uh, in
No.
any case, Terry, I think you've got your mic on. If you would turn that off, would really appreciate it. In any case, he's been out in the field. He knows what it's like to do international business, and he currently has a lot of international work going on in other countries as well. So he's not just any old attorney with legal background. He walks the walk and talks the talk, and he really knows what he's doing. And he has been with the District Export Council and been a very valuable member to the deck for a great number of years. And I think that he's even been the chair at least a couple of times, I think. And so we really appreciate all the work that Graham does for us. And I think that you guys are going to find the information for today really, really valuable. And so, Graham, with that, go ahead and take it away.
Thank you, Rudy. Well, I hope the information will be worthwhile to everybody. Let me see if I got my screen shared with you now, and let me thank you for attending and being with me today, because I want to visit with you about some of the legal aspects, and particularly the aspects of international sales contracts, because they're different from what you may think, and they may be more complicated than what you may think. And so let's talk about some of these issues as we work our way through our agenda today. And our agenda consists of these issues. First, how to manage risk for an Arkansas exporter. Why use a contract? Do you need a contract at all? And if you do have a contract, what are the essential terms of that contract? And what are helpful terms? I break a contract down into essential terms and helpful terms, and we'll talk about those separately. Next will be how to avoid disputes. And then we'll talk about what terms actually make up the contract, because clearly the terms of a written contract will be binding on the parties, but there could be some other things that do not make it into the written contract that could impose obligations on you. And then we'll talk about different contract forms. So first, let's talk about why we're here and what are your objectives. Well, I hope your objective is not to be an expert when you finish this, because I can tell you I continue, even myself, continue to learn things every day, and perhaps even think I know less each day than I did the day before. But I think our objective should be to try to identify risks and then manage those risks. And in large part, I think the risks are those things that maybe we don't know enough about, but when we see it in a transaction, we have enough judgment to ask somebody or to dig into it a little bit more. So I'd say our objective is to identify risk and then know where to find the answer to that risk. So as we go through the seminar today, I'm going to give you a checklist of things to consider when you're entering into a sales transaction. Now, before we get into the sales transaction itself, let me talk about political risks, because these are things that are outside perhaps the written agreement, but that can have a very important effect on your transaction. And you see that I've listed them. I won't read through them, but you'll see that these political risks do have an effect on your transaction, and you need to be aware of them as you are focusing on how to manage all of your risks in a transaction. Now, for those of you who've heard me before, I always start with a baseline. And this baseline are those things that I think help an Arkansas exporter manage risk the best. Now, as I go through them, you'll recognize that you can't always adopt these principles, because you might not, it may limit your sales too much if you do. But I think that these are a baseline, so that if you vary from one of them, then it should raise a flag that you need to think about the additional risk that you are incurring by varying from these. And the baseline risks that I see are, first, for an exporter to sell direct and never leave home. By doing that, you avoid some of the risks of doing business in another country and subjecting yourselves to the taxation or the rules about how to do business in another country. My next one sounds silly, but it is to sell only to good folks from a good place. And that is more significant than you may think, because selling to good folks may help you get paid and may help you develop a relationship, where selling to bad folks may work against you in the long run. And a good place is difficult too. And if you will look at studies about how the different countries and different parts of countries, and particularly industries in different countries, honor their contracts, honor the rule of law, and otherwise live up to the obligations that they incur, that can have a big impact on you too. So when I say a good place, it generally means a country that respects the rule of law. The next thing about managing a legal risk is to have your customer prepay in full, so you don't have to worry about getting paid. Now, that, of course, cannot always be done, but that's the baseline. The next one is to sell ex works, so that the risk of loss and possession and the title all transfer at your dock. And once they have left your dock, then your risks are minimized, even though they may not be totally eliminated. I suggest you sell without a warranty, or if there is an implied warranty, you disclaim that warranty. It's better to sell without bribing anybody. It's better to provide, if you're an Arkansas exporter, that Arkansas law applies rather than the law of some place that you may not know. And that if there is a dispute, then those disputes are going to be arbitrated in Arkansas. Now, again,
Graham, if I can just jump in for a second, since we have some people who are not from the United States.
Yes.
The thing that that Graham is trying to allude here, that in a perfect world, and obviously we do not live in a perfect world, but if we had our choices and it was a perfect world, these are the sort of things that you would do. But the reality is that we're not in a perfect world, and so Graham's going to cover what happens when you don't have a perfect world.
Well, and Rudy, that's exactly the point I made at the beginning, is that this is what I consider a baseline. When you vary from these, then you may incur additional risk, but you just have to think about how best to manage that additional risk. But this is this is just a baseline for, as Rudy said, a perfect world. But if you can do that, then you have managed your risk to the greatest extent possible, and you're in much better shape. Now, the first topic, before we get into the details of a sales contract, is, do you need a sales contract at all? And my offhand approach is no, you don't. You only need it if there's going to be a dispute. But how in the world, when you're first entering into a transaction, do you know whether there's going to be a dispute or not? And the answer is, of course, you can't. So you do need a contract. And as I will continue to say, the purpose of a contract is to avoid a dispute. Now, how do you avoid a dispute with a contract? Well, hopefully the contract will answer questions that could otherwise lead to a dispute, so that if there is a difference of opinion between the buyer and seller, they can refer to the contract and find the answer without going to court. So why do you want to avoid a dispute? Well, the answer there is primarily expense, delay, and the loss of the relationship between your other party. By having a contract and thinking through these issues on the front end, hopefully you can avoid a dispute so that you don't have to litigate or arbitrate. And let me tell you, litigation and arbitration are very expensive. Even a simple contract dispute in Arkansas can cost at a minimum $20,000 for each party and legal fees and so forth. But a major case, particularly if it's international, can incur legal fees of over $1 million. So it's much better on the front end to avoid a dispute by providing in the contract those issues that you want, or that may arise as disputes later. Now, we hear a lot about, well, just give me a one-page contract. Well, that sounds good, doesn't it? But a one-page contract may not satisfy our objective of providing all the answers that we need in order to avoid a dispute. Now, even though you don't have a written contract, the law itself may supply virtually every term for a contract. The problem that you'll find is that the terms that are supplied by the law may not be the terms that you want. So yes, you can skip a contract, or you can have a one-page contract, but my recommendation is that you have a thorough enough contract that it covers every area on which there could be a dispute. And the reason for that, again, is to avoid the time delay, the expense, and the loss of the relationship that you may have with your partner. So now let's dig into some of the contract terms and the ones that I call essential terms. First is knowing your buyer. And that doesn't just mean making sure you have the correct legal name and address in your contract, but it means making sure that your buyer is not on a sanction list. It means that you would like for your buyer to have assets in the United States or do business in the United States, so that if you have to sue them, you can sue them in the United States and collect your judgment without having to go somewhere else. Finally, it's very helpful to know your buyer by having references from other customers or from your buyer's bankers. Second essential term is price. We think the price is simple, but it may not be. You have to pick a currency. And what happens if that currency fluctuates between the time the contract is signed, and the time that the contract proceeds are received? What about weight and quantity changes? Weight changes can occur a lot more frequently in commodities, but it's possible that quantities can change even in manufactured goods, particularly if some of the items are not in working order, or if they fall off the boat, or if they're otherwise damaged in transportation. And finally, the price needs to consider who's going to pay the taxes, the insurance, the freight, the unloading, and the inspection. The third major component of essential terms is the payment. And I think there are two parts to that: timing and the methods of payment. The timing for payment is, of course, we prefer prepayment, but that's not always possible. Sometimes it's part now and part later, and we hope it's not going to be part never. But if we give credit, then we have to determine how best to secure that credit, or are we confident enough about the buyer that we're willing to give an open account? But there are insurance programs with XM and SBA and even private insurance that are not expensive at all, and they help provide security for an open account. And I certainly recommend that you get into those and learn about those as you're developing your open account policy. Another critical term is a detailed goods description. And of course, with manufactured goods, we have specifications that may answer the question. With commodities, those specifications can run to a page or two of very specific specifications. And so there needs to be a provision about what happens if the quality does not meet those specifications, or the quantity. And will the goods be inspected? If the goods will be inspected, then by whom will they be inspected? Many people use international independent testing organizations, particularly with commodities, to inspect the goods. And if they are inspected, then does that end the seller's risk? Now, I've seen some contracts, particularly where commodities are sold to companies in China, where the Chinese buyer wants the inspection to occur upon arrival in China by the Chinese inspection agency. Well, you can understand the risk of doing that and relying on the Chinese inspection. And what happens if it does not meet inspection? Then what do you do with the goods, whether they're manufactured or commodities? Next component is the delivery date. Often the goods do not arrive right on that date, but they can arrive early or late. And so who pays the additional costs? And if they're late, can the buyer cancel? Often there is a provision that if the goods are late by a certain number of days or months, then the buyer does have the right to cancel. But then the question comes up, can the buyer recover damages for the delay? And that, again, is something that has to be negotiated. Another final term that I'd say in essential terms has to do with the delivery method. I'm going to talk about Incoterms in some detail in a minute, but Incoterms is a method of incorporating into your contract terms that have to do with when possession transfers, when title transfers, when the risk of loss transfers, and then separately you need to consider what is the responsibility of the carrier. All right, let's talk about disputes, because although we try to avoid a dispute, those disputes do happen. And if they do happen, then we want to be able to refer to our contract to help us resolve it. And the first issue that comes up is which law is going to govern. Now, for those of you who are familiar with the laws of the United States, you recognize that the Uniform Commercial Code is adopted in pretty much the same form in all 50 states. So if you're dealing only in the United States, then it's pretty simple as to what law governs. It's the Uniform Commercial Code. But if you're dealing with a foreign sales contract, then it's very possible that the Uniform Commercial Code in America, particularly Arkansas, would not apply. And it is possible that something called the United Nations Convention on the Sale of Goods would apply. This is a treaty among several countries, and it provides that if both the buyer and the seller country, or buyer and seller companies are within countries that are parties to this treaty, then this set of laws in this treaty, this United Nations Convention, will apply. But how many of us have ever heard of that? And how do we know what the differences are between this and the Uniform Commercial Code that we may be more familiar with? Even more scary is what happens if it's the law of some place that who knows what the law is, and whether it is a recognized system of laws or whether it is a law system that is based wholly on the discretion of the courts. And so that is a particular reason to pin down in your contract what law is going to govern any disputes. The second aspect of dispute resolution is, where is it going to be resolved? Of course, for an Arkansas exporter, we want it to be resolved in Arkansas because we know what the law is, and we also know it's going to be cheaper for us to have our lawyer and our depositions and our court hearings right here in Arkansas. But an international buyer may not want that. They may not think the courts of Arkansas would be fair for them. And so they may specify some other place, and that is very common. Just keep in mind that if you provide that the courts of a neutral country like Sweden or Switzerland, or even the courts of New York apply, it's going to cost you a lot more money than it would if the dispute was resolved somewhere in Arkansas. And for sure, you don't want the place designated to be out there where who knows what the result may be, and who knows what the judges may use to make their decisions, and it may not be the law. Finally, there are two main methods of resolving a dispute. One is arbitration and one is litigation, and they have different promoters depending on who they are. Generally, I have found that arbitration can be handled quicker than litigation, but both of them probably cost about the same. But the time difference is a component and is a consideration for whose ox is getting gored. If you're the one being sued, then it may be to your benefit to delay as long as possible. But if it's you who is entitled to the money, then you may want to resolve the case as quickly as you can. So each of those require some considerations. And if you're trying to consider which of the two is better at the time you enter into a contract, then it does require some thought. Now let me switch to helpful terms, because these are terms that I recommend should be in a contract, but this is where people's eyes get glazed over, particularly at the time of entering into a contract, because they say, oh, this will never happen. My party is my good friend and everything's going to be just fine. But let me remind you that in America, almost half of the marriages end in divorces. And if that's the case, then let me tell you, I think business transactions probably have about the same win-loss relationship. We hope they don't, but they can. And so it's better to think through what's going to happen in case there's a problem rather than just work it out at that time through the courts or through arbitration. First, one of those terms has to do with a warranty or disclaimer. You will find that in the Uniform Commercial Code in Arkansas and as it exists in many countries, there are implied warranties that you may not even know about. The law implies warranties into your sales contract that puts obligations on the seller that can only be eliminated if there is a specific disclaimer of those warranties. Another issue that comes up that I'm sure you're familiar with is what do we do about service? What happens if it breaks or if the item shows up in a bad condition, or what if it works for a while and then breaks? What is the customer going to assume or expect as far as the service? And that, of course, is a very expensive and detailed consideration that you need to think through. Indemnification is a legal term, but basically it means that if you get sued, but it's not your fault. And generally this comes up is when perhaps your distributor doesn't take care of the goods and their customer sues the distributor and sues you as the manufacturer. It's not your fault, but you still get into the lawsuit. And the question becomes, will your distributor indemnify you against your attorney's fees and against any judgment that may be rendered against you? A very difficult issue is protection of intellectual property. You know, should you try to protect it? How? And can it even be protected? Often companies, when they're not sure of the reliability of their buyer, will not sell the most technologically up-to-date model, but they'll sell an older model so that if the technology is stolen, then it won't be their latest model. But sometimes that can really be a problem. Confidentiality. Do you mind if your customer shares your price and terms with others so that your customer and other customers get together and discuss whether they're getting the same deal from you? Non-competition. Can your customer compete with you? Do you mind if they later decide to go into business either manufacturing your product through reverse engineering or in some other way competing with you? Of course, generally our hair catches on fire when that happens. We're so angry, but it's something to consider up front and to discuss whether we want to avoid it or not. Non-solicitation, that's a very easy way for your customer to compete with us by just hiring your smartest people. And if they hire your people, then they don't have to invent all your methods and intellectual property. They have your own people to do that for them. And sometimes diversion is an issue. And that's where you may have a contract to give your distributor an exclusive territory, but that distributor then sells into another distributor's territory, and that can cause you problems with both distributors. I think it's important for us to consider local fairness risks, and this goes back to being in a good place. These are not necessarily things that you're going to find in your sales contract, but they are components of you doing business in a foreign country. And corruption is the basic bottom line. But as you see, before we get too cocky about it, that in the ranking of corrupt areas, the United States is not the least corrupt. It comes in at around 22, where Europe as a whole is around 17 and Asia is 62 in ranking. So there are issues of fairness that will affect your sales. Let's take a minute and just dig into Incoterms for those of you who may be vaguely familiar. The Incoterm rules determine obligations between a buyer and a seller. They determine when the risk of loss transfers between a buyer and a seller, and they determine which costs a party must pay. Now, what they don't do, and this is where we mess up a lot, is they don't create a contract. When you use Incoterms, you are just importing into your contract the Incoterm rules. So they don't create a contract. They don't have anything to do with the method of payment or the remedies for breach or a force majeure or a dispute resolution. All of those are handled outside Incoterms. Now, when you're incorporating Incoterms in your contract, the best way to do it is to specify the Incoterm that you want to use and then name a port, place, or point, and then use the phrase Incoterms 2020, because there are new Incoterms every 10 years, and we are now using the Incoterms 2020. So, for example, CIF Shanghai Incoterms 2020 or DAP Street Address Conway, Arkansas Incoterms 2020 is the proper way to incorporate the Incoterms into your contract. Now, what are we incorporating? Well, basically, we're incorporating three things. And you look at this graphic, and the blue is the seller, and the yellow is the buyer. So the costs of transportation, you'll see under a CIP Incoterm, will show that the seller is obligated to pay the costs of transportation to the buyer's dock, but not for the unloading. Under CIP, the risk of loss ends for the seller when the products are loaded on the truck. So the buyer assumes the risk of loss from the time the goods are on the truck until they reach the buyer. But the third component is insurance. The seller is obligated to provide insurance for the benefit of the buyer. So let's look at this a little bit more. What happens if the boat goes down or the goods are damaged in transit? Who pays? Well, the seller has provided insurance for the buyer, but the risk of loss switched to the buyer at the seller's dock when it was loaded. So the buyer is obligated to make a claim under the insurance policy and to go through the hassle of trying to recover from the insurance. So even though the seller provided insurance, the risk of loss still transfers when the goods are loaded on the truck. Now, there is a graphic like this for each one of the Incoterms, but there's more. When you use an Incoterm, you're not just analyzing those few issues, but all of these issues that are on your screen now are incorporated into your contract and many of us don't realize it. But there's a list of obligations of the seller and a list of the obligations of the buyer. So even when you put X works in your contract, there are these obligations which may be imposed on you as the seller or you as the buyer, whether you realize it or not. The way to find out about it is to buy a book from the International Chamber of Commerce, which details all these rules for each of the Incoterms. And I recommend that if you do any international shipping at all, that you buy the book. Let me give you an example. There's a case about an MRI which was loaded on a ship in Germany in good condition, but it was shipped to Calumet, Illinois, and when it arrived, it was in bad condition. The buyer and seller had a one-page contract. The contract said that the MRI system would be delivered fully functional. And then it said CIF New York Seaport. And then it said the system remains the property of the seller until complete payment has been made. Well, who gets stuck with the defective or the broken machine? Well, it was agreed that the machine was put on, delivered to the carrier in good condition, you see, and it was loaded on the ship in good condition, but it was in bad condition when it arrived. You see in this one-page contract any reference to Incoterms? Nope. They didn't use the method that I mentioned a minute ago about specifying the Incoterms and the year. So what happened? Well, a court in New York ruled first that you had to determine which law governed. And in this case, they determined that German law controlled because there was a provision in the contract that German law controlled. But what is German law? Well, the German law apparently is that the UN Convention on Contracts for International Sale of Goods, what I mentioned earlier, would resolve these kinds of disputes. Well, what does it say? This is interesting because Article 9.2 of this treaty says that the parties are considered, unless otherwise agreed, to have impliedly made applicable to their contract a usage of which the parties knew or ought to have known and in which international trade is widely known to and regularly observed by the parties to contracts. So what that says is that in your contract, a court may imply terms just because the parties knew or ought to have known that they'd be implied. And the court said in this case, if these merchants were dealing in international trade, they should have known that Incoterms would have applied. And if so, then Incoterms is going to answer the question. And in this case, Incoterms did answer the question, and risk of loss shifted at the time the MRI was loaded on the ship, so that the seller won and the buyer lost. Now, what terms are in the contract? This is also something that may keep you from sleeping at night. Clearly, the terms written and signed by both parties and by their authorized representatives are in the contract. But sometimes terms that an unauthorized representative has agreed to could be in the contract. That unauthorized representative may be given power either by how you set himself up with the buyer. Maybe you call him a vice president. Maybe you call him a vice president of procurement. Maybe the unauthorized representative, he or she does something which you later say, well, okay, that's okay. So even though an unauthorized representative may agree to some terms, those terms could be in your contract. Similarly, sometimes oral terms can be in the contract, and that's why you see in many contract boilerplates where they provide, regardless of anything else that happens, only what's signed by the two parties is going to be part of the contract, and no oral terms will be included. Next thing is implied terms by usage in trade. Well, we just saw where a court in New York held that Incoterms can be implied in a sales contract even though they are not specifically incorporated. The next one is implied terms by law. I mentioned earlier that there are some implied warranties in your sales contract, whether you know about them or not. Sometimes we incorporate terms from outside the contract in there, and sometimes terms are raised only by the other party, but you didn't disagree with those terms, and so they become part of the contract. Now, those are all issues that result in disputes. And so as we're forming our contract, it's much better to try to resolve those issues without waiting for a dispute. We see a lot of contracts that have so much fine print that our eyes either glaze over or we just don't take the time to read it or don't think they're negotiable, and they're probably not negotiable. And are we bound by them? Well, the answer is yes. We generally are bound by them because you don't have to buy that iPhone. You don't have to take out that app. You don't have to buy that stuff online. And so you are generally bound by it, but you may not be bound by it if the term is so unconscionable that a court will not enforce it. But again, you don't want to get into a dispute about that. So don't sign anything unless you are okay with assuming whatever the fine print says. Next, we use a lot of terms on our website. And there's been a lot of litigation about whether those terms are binding or not. And generally, the courts come down and say that if the parties had to do something affirmatively to acknowledge that they agreed to those terms, then they can be binding on you. And what that means is if you have on your website your basic terms and you have a place for the buyer to click that they agree to these terms, then the buyer is probably going to be obligated under those terms. If you do not, then there's nothing to show that the buyer agreed to those terms, and so they may not be obligated. I have made a checklist of some issues for distribution agreements. I won't go through them, but they'll be in the slides, and you're welcome to copies of these slides. These are issues that generally a manufacturer will want a distributor to agree to. And similarly, these are things that a distributor will want a producer to agree to. And all of those are matters of negotiation. Finally, let me repeat what I said before, that there are contract forms which are issued by the International Chamber of Commerce that you can purchase. And you can Google ICC online, and they have a form contract for sales, one for distributors, and so forth. And they may or may not fit your particular circumstances, but at least there's something for you to consider as you're developing your own contract form. And also, the International Chamber of Commerce is where you get the book on Incoterms. Now, let me summarize, because this is a lot of material. And what in the world do we do with all of it? Well, here's my suggestion, is that you sit down with either your export professional or your attorney or whoever your advisor is and develop a plan for transactions that will satisfy 80% of your sales, and develop those guardrails and those principles and those policies for those sales. Then go off and do business, and as long as you're within those policies, don't worry. Now, if something happens where you need to go outside those guardrails, then you may need to reconvene your group of experts together to make sure that you have covered the risks satisfactorily. But my point is, you don't need to have a lawyer or a trade professional look at each one of your contracts if you have developed a series and system of policies that will handle you in maybe 80% of your sales. So I'm hopeful that you don't have any tough questions, but I'm happy to answer them in our time remaining. And you can also contact me at any time at no cost. By email is the best way to reach me to talk through any of the issues that you may have. This is my email address, because I'm happy to do it as part of my work with DEC, and we can struggle through the issues that you may have.
Graham, thank you so much. I think that you guys see why we're excited about having him talk about these topics. And ladies and gentlemen, the issue here is that the saying about you don't know what you don't know, and in this particular case, there's a lot that can escape you, and what we're hoping will happen by having looked at some of these terms and conditions and functions is to realize that, well, I didn't know about that. I had never thought about that. And so now it's on your radar screen, and you're, hopefully we'll start looking at those issues, because there's unfortunately 101 different ways to get trapped up into these things, especially if you just assume the best and make no effort on your part to try to mitigate some of these risks that are out there. Graham is going to be providing us, or I guess Heidi's going to be providing to us Graham's slide deck, because obviously lots and lots of information, and we wanted you to pay attention to what he's saying without the need to write down lots and lots of notes. And so you'll have his slide deck to act as a resource for you to go back at your leisure and see if there's something that you want to look at or to discover, and maybe even to contact Graham and ask him about those factors. Anyway, I guess, let me see here. I want to look at whether we have anything in the chat. Doesn't look like we have any questions. So let's go ahead and if you have a question, go ahead and unmute yourself and ask your question. Well,
all right. Well done, Graham.
Thank you, Jonathan.
I guess
I've
everybody's
confused
dumbfounded.
everybody, I think, or scared the heck out of them.
That's right. That's right. One thing that you mentioned about, having a contract in place, it's, as a guy that works with businesses, I see companies, it's hard enough to find a client, here. When you're out there building your book of business, it's definitely harder to find a client overseas. So a contract is a great way to make sure that relationship stays intact. So I thought that was a really good point that you brought up, Graham.
Absolutely. If there's the discussion, or I remember it differently than that, you go back to the contract, and there it is. And so obviously everybody's memory can be faulty from time to time, and just the fact that you understood it differently, that's part of being human. And so the contract will alleviate some things that could really degrade into a serious dispute very readily. And so here's the reality, is that everybody, I should say, nobody wants to pay attorney fees. And I get that, but man, it's either pay me now or pay a whole lot more later on. And there's other costs involved besides just the legal fees of an attorney. So here's some information for you guys to consider, to look over. And if you have your own attorney currently and you don't think that X is being covered, then talk to your attorney or talk to Graham and see what he thinks about whatever issue you're bringing up.
All right. So, yeah, I don't see any questions in the chat. Obviously, if anyone thinks of something later, reach out to Graham or Miss Heidi, myself, or Rudy, and we'll track down an answer for you. But with that, I appreciate everyone's time. Graham, thank you for the great conversation. Miss Heidi is showing on the screen our next webinar, Doing Business in Australia. I'm looking forward to that one. Obviously, but anyway, thank you again to the Arkansas Economic Development Commission and Arkansas Manufacturing Solutions for their sponsorship in our webinars today. So thank you all very much for joining us, and I'll speak to you next time.
Yeah.
Bye.
And Ms. Heidi, can you go ahead and put that last slide back up so that people can perhaps take a picture of the email addresses in case they wish to contact any of us, please?
Oh, sure. Just one moment. I just realized I forgot to put the survey link in the chat. So I was going to do that. Just a moment.
Yeah.
I will send everyone the survey link in the email that you'll get shortly.
Yeah. And if you can fill out the brief survey, that would be very useful. That way we know what you think about the webinar, whether there are improvements we could make, and what those are. So we would really appreciate if you would fill out the brief survey. But once again, here are the various emails. There's Graham, mine, Jonathan's, and Heidi's as well. And if you feel like you want to ask a question or make a comment to any one of these people, feel free to do so. And once again, thank you so much. And we hope that we see you on the next webinar, Doing Business in Australia. And we will call it a day then. Thank you so much. Have a great day.
Bye, everyone.
Rudy, just one question here.
Yes, sir.
Could you please share this presentation with us? To share this slide for all the
yes, sir. We're going to send
Yes,
you. Yeah, we're going to send all the slide deck. And as a matter of fact, we're also going to have on YouTube. We're going to have this actual webinar that we're part of today, so that you can go back to it and see the whole thing as many times as you want.
And congratulations, the presentation is not only for Arkansas, it's valid for all over the world.
Absolutely. All these questions and issues apply to every entity in the world. These are questions that everyone should be asking themselves. No question about it.